Now, those who survived the Marikana massacre say nothing has changed 8 years on. Retired Judge Farlam headed an inquiry into the massacre. He believes that not much has changed and that important recommendations in his report haven't been implemented. He joins us now on the line. Judge Farlam, good evening. It's a pleasure to have you on. The process of having the Commission of Inquiry was supposed to trigger what would be the beginning of justice for many of the families who've been affected by the violence that took place in Marikana. 8 years on, that doesn't seem to have been the case. Do you see your inquiry as having been a failure?
Well, possibly it's too early to say it was a failure, but I certainly am very disappointed, and I'm sure everybody else is, that nothing has come of the recommendation we made that the provincial Director of Public Prosecution should appoint a special team to investigate the criminal aspects of the matter, and we recommended specifically that the conduct of all the police persons involved at scene 1 and scene 2 should be investigated to see whether they were criminally liable. Now, we suggested that a special team be appointed under the chairmanship of a senior state advocate. I understand that was done, the team was appointed, but we've heard nothing since. I don't know whether they in fact conducted the investigations. But I would imagine if they had done so, there would have been a number of policemen who were going to be prosecuted. But there's absolute silence on the matter. It may be that they weren't given the funds. There was a story that they applied for funds for the investigation, and they didn't get the funds. I don't know what's happened since then. But certainly it's a deafening silence, which is very, very regrettable.
How does that make you feel? Because in many respects, the people, especially the widows of Marikana, were looking to you and were looking to the outcome of your process to lead to some form of justice.
Yes. Well, you know, we had so many matters to investigate that we used we made use of a passage in the regulations which said that we could refer particular inquiries to other bodies. The problem we had with the prosecutions was the evidence that was given to us by the police could not be used against particular people who gave the evidence in any trial in favour of the accused. But that's what the regulation said. And furthermore, most of the police had made statements to IPID, and in terms of the IPID Act, any self-incriminating statement a member of the police force makes to an IPID investigator is also inadmissible. So we were afraid that we recommended that people be prosecuted. The DPP would turn around to us and say, but what evidence have I got? Because what they told you I can't use, the statements they made to IPID I can't use, so on what basis can I prosecute? So we thought the sensible thing to do was to say that the DPP must go make his own investigations. We cleared all the undergrowth away, as it were, and then make his decision on whom to prosecute on what evidence he had available. That's why we referred it to him. But we expected that would be done promptly. And as the years have gone by, it's become more and more unsatisfactory that nothing appears to be done.
Do you think that there is political will to actually not just have those matters investigated, but ensure that there are, in fact, prosecutions that come out of that process?
Well, I don't know. It would obviously be speculation on my part. There may be reasons which I don't know about. I don't like making critical comments against people. If there are things that I don't know, there may be something that can be said in their favour. But certainly, prima facie, it appears to be very, very unsatisfactory.
Of course, part of the difficulty here, Judge Farlam, is the fact that the work that you did is now seen as and described by some of the people of Marikana as having been a waste of time, and also being seen as a pacifier that basically was there to keep them quiet, to shut them up, but has not yielded any results. And so ultimately, there are big questions over whether or not the country could have done without the inquiry.
Yes, I'm sorry that they think that, because I must say I don't think that that's correct, and I'll tell you why. The after our report came out, one of the council made a statement to the press that his clients were very disappointed because we had decided nothing. Now, that wasn't true. What we decided, first I would tell you, for about a year, the police came and put up a number of false versions before us. It took a long time for the false versions to be exposed for what they were and to get to the true facts. But there's another aspect that's important. I don't know that people realize that an R5, which is the weapon used by the police, is the most unsuitable weapon to use for public order policing. And I would hope that they don't use it anymore. We certainly recommended very strongly that they discontinue using it. One of the things that R5 does is it's designed for use on the battlefield. The bullets that are fired from the R5 disintegrate when they hit the target. So it was accordingly impossible to show which policeman had killed which striker, because we knew people had been killed. We knew lots of bullets had been fired. In fact, at scene 1, 328 bullets were fired in 8 to 12 seconds, and at scene 2, 268 bullets were fired in also a short period. But it wasn't possible to link any particular policeman with any particular death. But what we found was that the government were liable, the police were liable on what is known as the McCann principle, because the police should not have been in the situation to have to fire those shots, because they believe, certainly at scene 1, we found they believed reasonably that they were under attack from the strikers. One can details of that. That was our finding. But it didn't matter. Some policemen may well have fired in circumstances where they were acting in putative self-defense. Some strikers may have died as a result of that, so there would be no claim based simply on the firing. But because the plan was defective, because the police had never been put into that position to deal with the situation, the plan principle said, on that basis, the government's liable. Now, our finding was actually very important for all the people who were claimants in respect to what happened on the 16th of August, because they didn't have to go to court to prove who fired which rifle and who was killed as a result, because there was a blank finding in respect of each one of them. And in fact, I understand that the case that was then brought was based, amongst other things, on that finding and on that principle. So it's very unfortunate that they didn't realize that in fact, by making that finding, we in fact created a situation where the government were obliged to concede that they were liable. And I understand that they did make that concession. The problem apparently relates to the amount of compensation. The compensation is divided into two parts. There's the loss of support claim. In that respect, I understand the government appointed one of my former colleagues in the appeal court to go into the case to make a report as to what amount he thought would be the appropriate amount for the loss of support. And I assume that the government accepted that the recommendations he made. The claimants, I understand, do not accept the amount offered by the government, but I also understand, and I'm not sure if this is correct, but this is what I was told, the difference relates more to their feelings of pain and suffering and distress at circumstances in which their loved ones were killed. It's the principle that the former Chief Justice applied in the case involving the people in care homes in Gauteng. And I think, from what I'm told, that's the sticking point. It's unfortunate that this matter hasn't been cleared up. But 8 years down the track, people are still waiting anxiously for the compensation to which they're entitled. But that's the background, as I understand it. But I'm sorry they're disappointed with us. We certainly did our best. We, I think, substantially discovered what happened and tore away the lies that we were told by the police.
All right.
But the other matters, of course, that are still outstanding. To me, the most important one is what was the answer to the question that we asked over and over again, the why Thursday question. I don't know whether you want me to go to that, but what had happened was the police were dealing with a very difficult situation. They had strikers who were endeavoring to enforce an unprotected strike by violence and intimidation. the process of that, a number of people were murdered. Among the 10 people who died before the 16th, there were 4 people who worked for Farlam who were murdered, clearly by strikers. And the police had a very difficult situation to deal with. And they first of all dealt with it quite sensibly. They worked out a plan how to deal with the people who were overcopying with weapons in a way that was relatively risk-free. But they decided to negotiate sensibly, to negotiate with them first, to try to get them off the copy, try to get them to lay down their weapons in a peaceful fashion.